Welcome. This session covers two core themes: the nature of international law and how it is enforced. We'll also walk through how to approach enforcement-based questions in your exam. International law governs relations between states. Unlike domestic law, it lacks a centralized authority. There's no global police force or standing court with automatic jurisdiction. States must consent to be bound. And enforcement relies on cooperation, political will, and reputational pressure. This decentralized nature often leads people to question whether international law is real law. But in practice, most states comply with it because they value stability, reciprocity, and legitimacy. It's not about coercion, it's about maintaining order in an interdependent world. Enforcement in international law happens in several ways. The primary method is peaceful resolution, negotiation, mediation, arbitration, and adjudication. Where peaceful means fail, states may take lawful countermeasures like suspending treaties, imposing sanctions, or issuing diplomatic protests. These must be proportionate, targeted, and never involve the use of force unless in lawful self-defense or with UN Security Council approval. Reparation is another key form of enforcement. This can take the form of restitution, financial compensation, or satisfaction such as an apology or acknowledgement of wrongdoing. The aim is to repair the injury and restore legal balance, not to punish. Now, how do you answer a problem question on enforcement? Start by identifying the issues. For example, was there a breach? What enforcement options are available? Can reparation be claimed? Next, apply the legal principles to the facts. Was there an armed attack? Was the response necessary and proportionate? Were peaceful options available? Be clear and structured. Use legal reasoning, not emotion. Avoid listing rules in isolation. Instead, apply them to the scenario. Then conclude logically: was the act lawful or unlawful? And what legal steps can the injured state take? The key to success is not memorizing rules, but understanding how to use them to support a legal argument. This briefing outlines the key rules and legal. It is designed to help you apply the right legal authority when dealing with breaches, state responsibility, and the use of force. The United Nations Charter is foundational. Article 2.3 obliges all states to settle disputes peacefully. Article 2.4 prohibits the threat or use of force against the territorial integrity or political independence of any state. This is a jus cogens norm, meaning no derogation is permitted. Article 33 emphasizes peaceful means like negotiation, mediation, and arbitration when peace is threatened. Article 41 allows the Security Council to impose non-military sanctions, such as economic or diplomatic restrictions. If those fail, Article 42 authorizes military action. Meanwhile, Article 51 preserves the right of self-defense if an armed attack occurs. But any response must be necessary, proportionate, and reported to the Security Council. The Vienna Convention on the Law of Treaties sets out how treaties are made and terminated. Article 60 permits a state to suspend or end a treaty if the other party commits a material breach. A material breach means a serious violation of a key obligation essential to the treaty's purpose. Diplomatic law is governed by the Vienna Convention on Diplomatic Relations. Under Article 9, a host state may declare a diplomat persona non grata without explanation. Article 41 requires diplomats to obey local laws and not interfere in internal affairs. The ILC articles on state responsibility define how and when states are held accountable for wrongful acts. Article 1 affirms that any internationally wrongful act entails responsibility. Article 2 defines such an act as one attributable to the state and in breach of an international obligation. Articles 22 to 25 outline lawful countermeasures. These are actions taken by an injured state to induce compliance, but they must be proportional, targeted, and non-forcible. States cannot use military force as a countermeasure. For reparation, Articles 34 to 37 identify three forms: restitution, which restores the situation before the breach; compensation, for financial loss; and satisfaction, such as apologies or official acknowledgements. Soft law instruments, though non-binding, carry persuasive weight. Principle 2 of the Rio Declaration states that countries have the right to use their resources but must ensure they do not harm the environment of other states. Customary international law arises from consistent state practice and legal belief. Jus cogens norms like bans on genocide, torture, and the use of force are absolute. The Caroline Doctrine remains relevant in defining lawful self-defense. Force must be necessary, immediate, and proportionate, leaving no moment for deliberation. Let's begin with the Nicaragua v. United States case from 1986. The International Court of Justice ruled that the U.S. violated international law by supporting Contra rebels and laying mines in Nicaraguan waters. Crucially, the court emphasized that self-defense under Article 51 of the UN Charter requires an actual armed attack and not just political or logistical support to rebels. This case defined the threshold for armed attack and reinforced the principle of non-intervention. Next, the oil platforms case between Iran and the US. Decided in 2003. The US argued that its attacks on Iranian oil platforms were lawful acts of self-defense. However, the court rejected this, ruling that the evidence did not show an armed attack by Iran. The case reaffirmed the criteria of necessity and proportionality in self-defense, and stressed that any claim under Article 51 must be supported by solid factual evidence. Now to the Palestinian Wall. Advisory opinion in 2004. The ICJ found Israel's construction of a wall in occupied Palestinian territory to be contrary to international law. The court rejected Israel's claim of self-defense under Article 51, stating that the threat did not originate from another state. The case clarified that Article 51 cannot be invoked against non-state actors unless clearly attributable to a state, and reaffirmed the inadmissibility of acquiring territory by force in the armed activities on the territory of the Congo case. Decided in 2005. Uganda was found to have unlawfully used force and occupied parts of the Democratic Republic of Congo. The ICJ ruled that Uganda had violated the DRC's sovereignty and committed acts of looting and human rights abuses. The case confirmed that military occupation without UN authorization or lawful self-defense constitutes aggression and attracts full state responsibility. Now, let's examine Gabikovo Najimaro's project, a 1997 ICJ judgment involving Hungary and Slovakia. Hungary unilaterally suspended a treaty to build a dam, citing ecological concerns. The court acknowledged environmental risks but held Hungary's suspension was unlawful. This case clarified the limits of necessity as a legal excuse for non-compliance, and explained when treaty suspension under Article 60 of the Vienna Convention is valid. In the Namibia Advisory Opinion of 1971, the ICJ addressed South Africa's illegal occupation of Namibia under apartheid. The court held that continued presence in Namibia was unlawful after the UN terminated the mandate. This case clarified that a material breach of a treaty may justify termination under Article 60, and that the international community has a duty of non-recognition toward illegal situations.